Directive principle of state policy. This is part 4th and article 36 to 51 of the constitution. Irish constitution से लिया गया है, which is copied by the Spanish constitution. Dr. Ambedkar described the novel feature and DPSP along with the fundamental rights contain the philosophy of the constitution and soul also. It is a conscience. The DPSP denotes idea of the state should keep mind while the formulating policies, and that was accordance with the article 36 the state part 4 and part 3 dealing with the fundamental rights. It includes the legislative executive organ, and the DPSP was an instrument that was Government of India. In the word of Dr. Ambedkar, DPSP like the instrument of instructions which is the Governor General and to the Governor of Colony of India by the British government. What is called the DPSP is merely another name of the instrument of instruction, and the only differences is that are the instrument of the legislative and executive. The DPSP is a very comprehensive economic, social, political program and aim at realizing the justice, liberty, equality, fraternity and preamble of constitution. This embodied the welfare and the police state and economic and social democracy, non-justifiable and not legally enforceable by the court and compelled to implement them. Nevertheless, the constitution itself says that these principles are fundamental in the government of the country, and it shall be duty of the state to apply this principle. The DPSP through the non-justifiable help the court to examine the determining the constitutional validity of the law. Article 14, equality before law. Now there is a socialist principle to promote the welfare of the people and the social order. That was 38, equality and equal income, to secure the right to adequate mean of livelihood and the prevention of the concentration of the wealth, and equal pay for equal work and prevention of the health. So that was article 39. To promote the equal justice, 39A, to secure the right to work, 41, to provide the just and human condition, 42, to secure the living wages, that was 43. To take a step to secure the participation of worker, 43A, to raise the level of nutrition, 47. To organize the village panchayat, that was Gandhian principle, 40. To promote the cottage industry, that was 43B. To promote the education for SC/ST, that was no exploitation, 46. To prohibit the consumption of the intoxicant, 47. To prohibit the slaughter of the cow, 48. Liberal and intellectual principle to secure all citizens informed throughout the country, to provide the early childhood care and to organize the agriculture, animal husbandry, to protect, improve the environment, that was under article 48. and 49 to improve the monuments and national importance के जितने भी हैं, जुडिशरी एंड एग्जीक्यूटिव को सेपरेट होना चाहिए, दैट वाज आर्टिकल 50. एंड प्रमोट द इंटरनेशनल पीस एंड सिक्योरिटी, दैट वाज आर्टिकल 51. ओके, नाउ द न्यू डायरेक्टिव प्रिंसिपल ऐड किए गए टू सिक्योर द अपॉर्चुनिटी हेल्दी डेवलपमेंट ऑफ द चिल्ड्रन, सो दैट वाज 39. प्रमोट इक्वल जस्टिस, 39A, दैट वाज अंडर द 42 अमेंडमेंट. एंड टू टेक द स्टेप टू सिक्योर पार्टिसिपेशन ऑफ वर्कर, 43A. To protect, improve the environment, 48A. 44 amendment added the one more DPSP, which is state minimum equalities. 86th amendment was changed the article 45 and made the elementary education. The amended directive provide the early childhood care. 97 amendment was a new DPSP to cooperative societies and cooperative society and article 43B. B.N. Rao was the advisor and recommend that the right of an individual should be divided into two categories, justifiable and non-justifiable. So part 3rd of the DPSP, which are non-justifiable, incorporated part 4 of the constitution. So the DPSP was make it clear that these principles are the government and it shall be the duty of the state to apply. Thus they impose the moral obligations for the application. Real force behind them is political. So no ministry responsible to the people can be afford. Article 4 was the constitution. Similarly, Ambedkar said the constituent assembly, a government which rests popular vote, can ignore the DPSP. Now the country did not possess sufficient financial resources, the presence of the vast diversity of the backwardness of the country, the newly born independent Indian states, and the constitution maker therefore taking a pragmatic view believed more awaken public opinion. Criticism is that DPSP has been criticized by some members. So what are there? No legal force. DPSP criticized mainly because of non-justifiable, while the KT Shah dubbed them and pious, spurious, and now payable only when the resources are permitted. So Nasiruddin contend these principles are no better than the New Year resolution. Illogically arranged. These principles are illogically arranged and conservative. Ivor Jennings was saying these are political philosophy. The ghost of the Sydney Webb and talk about the page part 4 of Constitution express the Fabian socialism. Okay, now next one is constitutional conflict. So K. Santhanam was DPSP is a constitutional conflict. There is lots of conflict. Utility of these rights are the utility because of lots of reasons are there. So what are the utility? First, they are like an instrument as a general recommendation addressed to all authorities. They remind them basic principle and new social economical order. They have served as a useful beacon light for the courts and help to the courts. They are dominating background to all state legislative execution and also guide करते हैं court को. They are amplify the preamble which solemnly resolve the secure the citizen of India justice, liberty, equality. They facilitate stability and continuity in political, economical, social sphere. They are supplementary to the fundamental rights and intended to fill the vacuum of Part 3. They implement create a favorable atmosphere for the political democracy. They enable the opportunity to exercise the influence control over the government. They serve as a crucial test for the performance of the government and they serve as the common political manifesto. Now next one is justifiability, fundamental rights and non-justifiable. DPSP on the other hand is a moral obligation and conflict होता है तब भी. In the Champaran Doraje case, the Supreme Court ruled that case conflict between the fundamental rights and DPSP, the former will be prevail. So First Amendment and the Fourth Amendment and the Seventh Amendment is given. The above situation underwent major changes. Golaknath case was given the Supreme Court ruled the Parliament cannot take away, bridge the fundamental rights. It's sacrosanct in nature and fundamental rights cannot be amended for the implementation of DPSP. The Parliament reacted the Golaknath and enacted 24 Amendment and Constitutional Amendment. No law which seeks to implement social directive principle. Now next one is implementation of the DPSP. The Planning Commission ने establish हुआ था 1950 में and development of the country. So successive 5-year plan aimed at securing social economical justice called the Niti Aayog. Almost all the states have passed the land reform, bring the change in the agrarian society, abolition of the intermediate jamidari. The Minimum Wage Act and the Payment Wage Act was also, the Bonus Act was also there, and the Maternity Benefit Act, that was equal remuneration. Various measures have been taken to utilize the financial resources promoting the common good. Legal Service Authority Act has been established a nationwide network providing the competent legal aid for the poor. Lok Adalat is a statutory forum for the conciliatory settlement of legal disputes. And Khadi Village Industry Board, that was also there. Lots of boards are there. Community Development Program, Hill Area, Drought Prone Area, Minimum Need Program 74, Jawar Rojgar 89, Swarn Jayanti Gram Swarojgar 99, Sampurna Gramin Rojgar 2001, National Rural Employment 2006, Wildlife Protection 72 and the Forest Act, that was 1980, have been enacted safeguard of the wildlife also. Three-tier Panchayati Raj system was provided the 73rd Amendment and provided the constitutional status to the Panchayat. Seats reserved for the SC, ST and the OBC, and Untouchability Act was also there. Now the Scheduled Caste and the Scheduled Tribe Prevention of the Atrocity have been enacted to protect the SC, ST from the social injustice and exploitation. National Commission for the Scheduled Class and the Scheduled Tribe protect the ST, SC for the 89 Amendment. Now, various national level commission have been established to promote, protect the social, educational, economical interest of the weaker section. National Commission for Minority, National Commission for Women, National Commission for the Protection of the Child Right. Criminal Procedure Code separated, that was a public service for state. Primary Health Center and the hospital established for the country. Law of the prohibit of the slaughter of the cows also. The DPSP that was for the SC/ST के लिए. Article 335 and part 16 that was for the SC/ST. And Article 350A of the part 17 for the mother tongue में कुछ भी देना हो. Development of the Hindi is also there. Now we are discussing some rights. Definition, application of the principle, then state secure the social order, certain principle for the state and equal justice, organization of village panchayat, right to work, provision just human condition of the work, living wages and participation of worker, promotion cooperative society, uniform civil code, early childhood care, promotion of the education, economic interest of the SC/ST, and duty of the state to raise nutrition and organization of the agriculture, husbandry, protection of the environment and protection of the monuments and separation of the judiciary and the promotion of the peace and security. So these are some rights we discuss. Now fundamental duties are there. So rights and duties of the citizen are correlative and inseparable. Originally constitution contained only the fundamental right and not the duty. In other words, the framer of constitution did not feel it necessary for the fundamental duty. However, they incorporated these duties later in fundamental duty that was added 2002 on the more fundamental duties added. So that was in 76 and after then 2002. Fundamental duties we inspired by USSR and Canada, France and Germany. So the 76 Congress party set up the Swarna Singh committee and that was make the recommendation about the duty necessary which is felt the operation of internal emergency. The committee recommend the inclusion of separate chapter for the duties. 42 Amendment 76 Part 4A and the Article 51A which is the specify the code of fundamental duties in the ruling Congress. So that duties are the 8 fundamental parliament provide the imposing the such penalties, punishment and non-compliance of refuse कर ले कोई, no law imposing such healthy punishment. And now there is a some duties I can say like first is to abide by the constitution, respect करना है flag को, to cherish follow the noble ideal of the constitution, to uphold the protect the sovereignty, unity, integrity, to defend the country, render the national services, to promote the harmony and the spirit of common brotherhood, and to value preserve the rich heritage, to protect improve the national environment, to develop the scientific temper. I is for the property and J is for the towards the excellence of the all aspire. K for the opportunity education to his child towards the 6 to 14 year. Feature of these duties are some of them are duties which while the civic duty is also there like the DPSP there is non justifiable होते हैं ये भी ठीक है. The list of the duties is non-exhaustive but not covered. And now there was a scientific temple, noble ideals are justifiable, the non-justifiable character होता है इनका ठीक है. So क्या है significant क्या है इस duty का, तो critics भी बोलते कि part 4 of the constitution has reduced their value because of added the part 3rd as a fundamental right. Now they serve the reminder to the citizen कि आपको rights को follow करना है. They serve as a warning against the anti-national activities. They serve the source of inspiration for the citizen, create the feeling of the citizens, and they help the examining the determining the constitutional validity of the law and Supreme Court. So and Article 14 equality before law and the 6th right, they are the enforceable by the law. So Gokhale, then Indira Gandhi, then Prime Minister justified inclusion of fundamental duties, argued that their inclusion would help to strengthen the democracy, moral values and making the people conscious. The opposition of the parliament strongly opposed the inclusion of fundamental duties, and however new Janata government, that was Morarji Desai government was there. 42 amendment and the 43 amendment, 44 amendment, this show that there are the eventual necessity of disability including the fundamental duty. Verma committee, that was a prevention insult of the national honor, the various criminal laws and the provide for the punishable for the enforcement enmity between the different section of the people. So that was protection of the civil rights. Indian Penal Code declared the imposition, assertion, prejudice, national integration, Unlawful Activity Act of 1967, रिप्रेजेंटेशन ऑफ पीपल एक्ट, डिस्क्वालिफिकेशन ऑफ द मेंबर या फिर वाइल्ड लाइफ प्रोटेक्शन. सो दीज ड्यूटीज़ आर इम्पॉर्टेंट for this. Now there is the amendment of the constitution. So constitution of India is to provide the amendment in order to adjust the changing condition. So it is a flexible or rigid. So article 368 of the part 20 of the constitution was the parliament can amend the constitution and amend by the addition to violation or repeal of the provision of the constitution. So it is a basic structure. The amendment of the constitution can be initiated in the introduction of the bill of the parliament, and the bill is either minister private member does not require. Now the bill must be housed by the special majority, and each house must pass the bill separately, and disagreement between the two houses, it's no provision for the holding joint sitting. If the bill seek to amend the federal provision, it must also be ratified by the legislation of half of the state by the simple majority. After duly passed by the House of the Parliament, ratified by the state legislature, the President must give his assent for this bill. Type of the amendments are there. So amendment of simple majority, special, and amendment special majority with the half of the state. सिंपल majority में admission of the new state, formation of the new state, second schedule के जितने भी हैं emoluments, quorum हो गया, salaries हो गए, rule of protection of parliament हो गया, use of English language, number of the जजेस जितने भी हैं, यूज़ ऑफ द ऑफिशियल लैंग्वेजेस, सिटीजनशिप, इलेक्शन ऑफ द पार्लियामेंट एंड द डिलिमिटेशन एंड द यूनियन टेरिटरी, एंड 5th शेड्यूल एंड 6th शेड्यूल भी आता है. स्पेशल मेजोरिटी में क्या आता है, जैसे फंडामेंटल राइट या फिर DPSP होता है, उसको स्पेशल मेजोरिटी से ही केवल आप कर सकते हैं. स्पेशल मेजोरिटी विद द हाफ ऑफ द स्टेट, इलेक्शन ऑफ द प्रेसिडेंट या फिर एक्सटेंट ऑफ द एग्जीक्यूशन ऑफ द पावर ऑफ दिस या सुप्रीम कोर्ट एंड द हाई कोर्ट, डिस्ट्रीब्यूशन ऑफ द लेजिस्लेटिव पावर बिटवीन द यूनियन एंड द स्टेट, एनी ऑफ द लिस्ट हो गई 7th शेड्यूल की, या फिर रिप्रेजेंटेशन इन द पार्लियामेंट, पावर ऑफ द पार्लियामेंट टू अमेंड द कॉन्स्टिट्यूशन ऑफ द 368. नाउ द क्रिटिसिज्म क्या है बिल का, देयर इज़ नो प्रोविजन फॉर द स्पेशल बॉडी लाइक कॉन्स्टिट्यूशनल कन्वेंशन और द कॉन्स्टिट्यूशनल असेंबली. The power to initiate an amendment to the constitution lie with the parliament. Hence, the state legislation cannot be initiated bill proposal for amending the constitution. Parliament for the creation abolition of legislative council in the state. Here also the parliament can either approve or disapprove such resolution. So now the major part of the constitution can be amended parliament along with the either of the special majority or the simple majority. There is no provision for holding the joint sitting of both the House of Parliament if there is a deadlock between the House. On the other hand, provision of the joint sitting made here. So the process of the amendment is similar to that of legislative process. The provision relating to the amendment process is hence leave to wide scope of taking matter of judiciary. Despite there is a changing need and condition, the procedure is not a flexible as follow. So गुड बैलेंस बिटवीन फ्लेक्सिबिलिटी एंड रिजिडिटी होती है इनके बीच में. दैट वाज गिवन बाय द KC वियर. डॉक्टर अंबेडकर ने ऑब्जर्व किया था कि कॉन्स्टिट्यूशन असेंबली द असेंबली हैज़ नॉट ओनली रिफ्रेन फ्रॉम पुटिंग सील ऑफ फाइनलिटी एंड इनफेलिबिलिटी ऑफ द कॉन्स्टिट्यूशन बट extraordinary term of the condition of the America and provided for the procedure. So KC Weir has admired the variety of the amendments. This variety of the amending process was the Granville-Austin provided itself one of the most important for the constitution. Now the basic structure क्या होता है, तो basic structure जो है हमें शंकरी प्रसाद केस 1951 में बताया गया था. It is a first amendment curtail the right to property and challenge. The Supreme Court ruled that the power of Parliament to amend the Constitution also include the power of amend the fundamental rights. So Article 13 includes only the ordinary law, not the constitutional remedy. Therefore, the Parliament can abridge or take away the fundamental rights. So the Golaknath case, Supreme Court reversed the earlier stand and the constitutional validity of the 17th Amendment, which inserted Act 9 schedule. The Supreme Court ruled the fundamental rights are given the transactional of the immutable position. So Parliament cannot abridge or take away these rights. Okay. Parliament enacted the Supreme Court the Golaknath case enacting 24 Amendment. Act amending 13 and 368, it declared that Parliament has the power to abridge or take away the fundamental rights. However, the Keshwan and Bharti case of the Supreme Court overruled the judgment of Golaknath case. 24 Amendment. Fundamental rights are given the doctrine of basic structure, and that was mean the Parliament cannot abridge or taken away this right. The doctrine of basic structure was a Nehru Gandhi case. This case was Supreme Court was invalidated by the 39 Amendments Act, and that was the Prime Minister and the Speaker of Lok Sabha. All courts, the court was said that the provision was amending the power Parliament. The structure में कोई मतलब कुछ नहीं होना चाहिए. That is the supremacy of constitution, sovereignty, democracy, secular character, separation of power, federal character, unity, integrity, judicial review, freedom, dignity, parliamentary system, rule of law, harmony, principle of equality, free and fair election, independent judiciary, effective justice, principle of the fundamental rights, power of the Supreme Court and High Court. Now there is a Keshwaran Bharti case, Supreme Court and the separation of power between the judiciary, republic character, federal character, sovereignty, freedom of dignity, mandate, welfare and parliamentary system. Indira Nehru case, that was India is a sovereign, equality of the status and opportunity, secularism, government of law and not the man, judicial review and the free and fair election. मिनर्वा मिल केस में हारमनी रखनी है, जुडिशल रिव्यू होता है. सेंट्रल कोल में इफेक्टिव असिस्ट टू जस्टिस, भीम सिंह में वेलफेयर स्टेट, संपत कुमार रूल ऑफ लॉ जुडिशल रिव्यू एंड संबा मूर्ति रूल ऑफ लॉ जुडिशल, दिल्ली वाला पावर ऑफ द सुप्रीम कोर्ट, इंदिरा सानी केस रूल ऑफ लॉ कुमार, पद्मा दैट वाज इंडिपेंडेंट जुडिशरी, किहोतो फ्री फेयर इलेक्शन एंड सॉवरेन डेमोक्रेसी, एंड बोमई केस फेडरलिज्म, सेकुलरिज्म, डेमोक्रेसी एंड द सोशल जस्टिस. Chanda case, that was the power of the high courts, and Kuldeep Nair, democracy and free and fair election, and Ram Jethmalani case, power of the Supreme Court, and Madras Association judicial review and the high courts related जितने matter है. So this was about the basic structure. Now there is a difference between the martial law and the national emergency. Martial law, it is affect only the fundamental right. National emergency affect not only fundamental right but also the center state relationship and distribution revenue legislation power between the center and the state. It is government and the ordinary law से इसको पास कर सकते हैं, but it continue the government and ordinary law दोनों को ही, ठीक है. It is impose the restore the breakdown of the law. It can be imposed only the three ground: war, external aggression and the armed rebellion. That was the national emergency. It imposed in the some specific area. It imposed either whole or the country any part. तो ये सिर्फ स्पेसिफिक एरिया में होते हैं और ये केवल फंडामेंटल राइट को अफेक्ट करते हैं. ये फंडामेंटल राइट को भी अफेक्ट करते हैं नेशनल इमरजेंसी, एंड सेंटर स्टेट रिलेशन इज ऑल्सो अफेक्टेड. इट हैज़ बीन स्पेसिफिक प्रोविजन फॉर द कॉन्स्टिट्यूशन. इट इज स्पेसिफिक डिटेल प्रोविजन फॉर द कॉन्स्टिट्यूशन एंड एक्सप्लिसिट. So this is all about